Hello and thank you for joining me on this short video, Product Withdrawal. My name's Andy Bowles and I'm a food lawyer. Now this is the 59th in a series of 100 short videos that I'm recording on UK food law topics. You may be watching this as part of our online training service, in which case you'll have access to a whole range of additional resources. But if you're watching this on our YouTube channel, you are of course very welcome. Now when talking about product withdrawal, one has to compare it with another topic, which there is a separate video on, which is product recall. Now, product withdrawal is a situation where a food business operator, some running a business, for example, a factory or a warehouse or something like that, withdraws products from the supply chain. So typically with a product withdrawal, the food may have been imported, it may have been processed, it might be manufactured, distributed, but it hasn't reached the final consumer. It may have reached the supermarket, it may have reached the shop, it may have only got to the warehouse, but it hasn't actually reached the consumer. So a product withdrawal is getting it back, a product back from the supply chain, within the supply chain. Whereas a product recall is going that next step further, a situation where the product has already been supplied to consumers, and therefore a product recall is actually getting it back from consumers, from the customer. So what is the law on this? Well, basically what the law says, and this is just a paraphrase of it behind me here, but I'm going to read it from the screen. It says if a food business operator, so that's somebody who's running a food business, believes that a food which it has imported, produced, processed, manufactured or distributed, so we're talking about that initial sort of supply chain, is not compliant with the food safety requirements. So not being compliant with food safety requirements means there's something wrong with the food that is of great concern. It could be contamination, potential contamination with food poisoning bacteria. It could be potential contamination with food allergens. It could be contamination from the process. Maybe a bit of metal has got in there, a bit of rubber off the machine, something like that. So the food business operator is now aware that there could be something that affects the food safety requirements of the food. So the obligation in law is to do this. Immediately withdraw the food in question from the market, where the food has left the immediate control of that initial food business operator, and inform the competent authorities thereof. So those three obligations or three requirements there. Let's go through them, each of them. First of all, we've got believing not compliant with food safety requirements. Then we've got withdrawal from the market. And lastly, notifying the competent authorities. So, believing not compliant with food safety requirements, under what circumstances could that occur? I mean, it could be, I don't know, maybe it's part of the normal operation of a food safety management system, systems based on HACCP principles. Monitoring of a product by a manufacturer has identified a problem. Now, why would they just not do that before the food leaves the factory? Well, of course, in some short shelf life products, let's use the example of sandwiches, say in sandwich production. There may be some testing that's going on. There might be some samples of the food taken randomly during a process. They might be taking various other measurements during the process itself, where the results might actually take a few days to come through. So it may be, as well as just taking temperatures, which are obviously instant, or they might be doing other measures which are instant, which give an indication that everything's okay. They might be taking samples which might take 2 or 3 days to actually process, where the results come back and suggest there might be a problem. So if that's the case, the food business operator has become aware that the food may not comply with food safety requirements because there might be a food poisoning bacteria present. It might be that through routine checks, they're always checking the environment, they find maybe a piece of equipment has failed. Maybe when they're stripping it down, they find a motor has failed, or some part of a gasket or something like that. Bits of the equipment have gone missing. In other words, it's gone in the food. They've obviously got maintenance in place, they've got systems in place, but even the best maintained piece of equipment can fail on occasion. You'll know that if you've got a car. Sometimes, even though you get it properly serviced, things go wrong. So whilst they'll have preventative maintenance to ensure that everything's fine, very rarely you do get incidents where there could be equipment failure. If they become aware a piece of equipment has failed, then they might just think, well, it might be in the food. So they are obviously not, they believe, they don't necessarily have the full evidence, but they believe it's not compliant with food safety requirements. It could be the local authority has taken samples, which they do as part of their normal duties, and they may have picked up maybe a concern about high levels of bacteria or the presence of perhaps an allergen. It might be complaints are received by the business. Now, the complaints might not necessarily be all justified. It's very difficult sometimes when you're running a food business. People might complain, but they might be mistaken. But if you start getting complaints, you might think, well, actually, there's an indication there might be something wrong here. Clearly, there is a risk assessment that needs to be undertaken by the business. If there is clear evidence the food has failed food safety requirements, then the business must. There is a requirement in law, they must immediately withdraw the product from the market. But if they suspect and they're thinking, well, there might be a problem here, then they should act as soon as appropriate. Now, the requirement to withdraw the product from the market kicks in when the food has left the initial control of the food business. So, if we're back in our sandwich factory, we found maybe there's been a fault on one of the fridges and the temperature has gone too high. Now, the sandwiches that were in that fridge are now on the back of a lorry in the yard of the factory. They haven't gone anywhere. So what the food business operator would do as part of their HACCP system is they would put in a corrective action. They would pull those sandwiches back off the lorry. They would be probably destroyed because they've gone outside of the required temperature control. Now, the food hasn't left the initial control of the food business operator, it's still in their factory, so there's no requirement for them to withdraw it because it hasn't gone anywhere. There is also no requirement for them to notify the competent authority, which is the next duty, which I'll talk about in a moment. But if the food has left their initial control, now leaving initial control could be maybe in that situation they find the fridges of their sandwich factory have failed. But because they're working very quickly, it's a short shelf life product, they've already loaded the sandwiches on the back of a lorry, and the lorry is now trundling off down the M1 or something, but the lorry is not owned by that company. That lorry is a third-party distributor. So in other words, in those situations, the food has left the initial control of the food business operator because it's now on an independent lorry going off to a warehouse or going off to a supermarket. Under those circumstances, they must withdraw it. So they must get it back from that person and they must notify the competent authority. So I've said notifying the competent authority. What am I talking about there? The competent authority in the United Kingdom will be the local authority. So typically, if it's going to be, for example, a food poisoning or food allergen issue, then it's a food hygiene issue, and therefore it will be Environmental Health Department which would be notified. If it were a labelling issue, for example, they put the wrong label on the food, which means that an allergen is not properly declared, so it's a food information issue, that will be a food standards issue, and therefore it will be a trading standards issue, and the local trading standards department should be notified. However, for food businesses, the Food Standards Agency make it much easier for you. So if you go to the Food Standards Agency website, there is a way of notifying the competent authority. Obviously, you're notifying the Food Standards Agency, and they will notify the relevant local authority. Now, if you're a manufacturer, importer, distributor, something of that nature, you should already have all your contact details of your local authority within your contingency planning. So should there be a need to notify them, you should have all of that updated information readily available. But if for some reason it's not, remember you can go to the Food Standards Agency. If you're thinking, well, should we be notifying the Food Standards Agency? Won't we get in trouble? The fact is you are required under law to notify. If you don't notify your local authority, or even if you did notify your local authority, they would, under certain circumstances, be required to notify the Food Standards Agency anyway. So it really is important that you notify. If you fail to notify and it's found that you failed to respond in that way, then you can actually face legal action for failing to notify. So it is a serious issue. What about retailers? I've mentioned that the obligation is on importers and manufacturers and distributors and so forth. But obviously, if a food has reached the supermarket or the corner shop or the restaurant or the takeaway, then product withdrawal will affect them. And there is a legal duty placed on Retailers, it says to initiate procedures to withdraw from the market products not in compliance with the food safety requirements and participate in contributing to the safety of the food by passing on relevant information necessary to trace the food and cooperating in the action taken by the producers, processors, manufacturers and all the competent authorities. So in a product withdrawal, basically it's a legal obligation for the retailers to participate in that withdrawal. If you're notified as a retailer that a product has failed food safety requirements or is part of a product withdrawal, then what you should do is you should remove that from the shelves, remove it from the menu, and if you're in any doubt, you can contact your local authority who will be able to advise you further. There we are. That's just a few words on product withdrawal. There is, of course, a lot more information on our website, but thank you for listening and hopefully you'll join me on my next webinar. Cheers.